Hi, this is Kathleen Bonzik, and it is well settled in this country that sexual harassment violates Title VII of the Civil Rights Act of 1964. But if you look at the language of the statute of Title VII, you will find absolutely nothing there to state that sexual harassment is prohibited under the law. So, how can it be? How can it be that sexual harassment is barred by Title VII if the statute says nothing about it? Well, in the late 1970s and early 1980s, the United States Equal Employment Opportunity Commission began entertaining a lot of cases where people would come to the EEOC and charge their employers or their prospective employers, in the case of an applicant, with sexual harassment and advance the theory that sexual harassment was a form of sex discrimination and therefore was an unlawful employment practice pursuant to Title VII. And the EEOC agreed. This matter ultimately went to the United States Supreme Court. And in a case called Meritor v. Vinson, a ruling was issued back in 1986. And the Supreme Court found that yes, sexual harassment was a form of unlawful sex discrimination under Title VII. And that happens frequently. Congress will pass a law, and the courts interpret it and construe it in such a way that the law evolves. Now, there are two forms of recognized harassment in this country. One is quid pro quo. The other is hostile environment. What's the difference? Quid pro quo can only occur at the hands of someone who is in a position of authority over the victim, where there's an abuse of that authority. A classic example would be a supervisor who refuses to grant some sort of term, condition, privilege of employment to an employee unless he or she engages in some sort of sexual activity, gives a sexual favor. If you want this promotion, you must have sex with me. Quid pro quo is a Latin term that means something for something. The other form of recognized harassment is hostile environment. And this does not necessarily have to involve a supervisor or someone with authority over the employee in question. This could also involve coworkers, visitors to the workplace, as well as organizational higher-ups. And there's no exchange or promise of an employment term or condition or privilege that's granted. It's actions in the workplace, it's conduct, it's behavior that the victim finds offensive, unwanted. This could be the sexual banter, jokes, screensavers. Typically, one example in and of itself will not rise to the level of hostile environment. It usually involves more, but again, every situation is evaluated on its own. There is absolutely no cookie cutter approach to determine whether or not a particular set of circumstances constitutes sexual harassment. This is Kathleen Bonzik. Thank you for listening and for watching.